I want to thank Carolyn Stein, the director of the Washington State Science and Engineering Fair, Bill, and Carolyn's entire team for putting together an amazing event. It's really a great opportunity for the future leaders of the state, the country, the world, to have an opportunity to present, to have an opportunity to hear presentations of others, to dialogue, network. I really think it's a very valuable and worthwhile experience, and it's an honor and privilege for me to be here today. Thank you again, Bill, for having me. Bill had referred you to a presentation I gave last year, and I too encourage you to take a look at it. One of the things that I've observed in today's science fair program is there are a lot of students that are disclosing their inventions to the public, and it's unclear to me whether those students have taken any steps yet to protect their invention. According to the topics I talked about last year's talk, one of the pitfalls of patent protection is losing your rights to foreign protection by making any disclosure of your invention, any public disclosure of your invention. So to the extent that any of the students have disclosed their inventions today in public, they may have compromised their ability to get foreign protection, although in the United States you still have 1 year. So there's a lot of pointers in last year's talk that are well worth keeping mind of, and for those of you who are returning next year, you may want to consider having a provisional patent application filed at a very low cost for the purpose of locking in your rights to foreign protection at a later date. Between the time I came last year and today, there has been a revolution in the technical world. That revolution is brought about by AI, which is artificial intelligence. You can't go a day without reading about how AI is changing the lives of the world, the economy, technology, and the lives of every person. Just today, there's 2 articles of note that I'll just mention to show the significance of AI in the world today. I read an article this morning about the CEOs of both Google and Walmart turning in their resignations. These are the top people in 2 top companies. And when they were interviewed as to why that happened, the nice spin was that they were opening the door for leadership, new CEO leadership of people that are more versed in AI and how to deal with AI, because that's the future these companies see. Another article I read today came from Google, what Google is doing, and Google, which is a premier company not only in browsing and a number of other areas that they're in, but they're a leader now with AI with their Gemini AI module. They've introduced for their software engineers a premier AI coding device that's only available to some of the top software programmers within Google, which has an amazing ability, as I've read, to be able to do amazing things with coding at super high levels. And that's what AI is doing. It's actually at the point of writing code that was previously written by software engineers. So to make the statement that AI has changed the world is almost an understatement. It really is a sea change, and that's why today's talk is very timely. And without further ado, let me dive into that talk. The topic of today's presentation is navigating your IP through AI in the workplace. And I can't really cover with a good understanding for you what AI has done to intellectual property without talking a little bit about what intellectual property is. You need to know the fundamentals of intellectual property before I can talk about how AI has changed those fundamentals. And the short of it is the intellectual property remains unchanged. There's still patents, there's copyrights. There's still patents, there's copyrights. There's another bucket of IP known as trademarks. There's trade secrets and the catch-all bucket, unfair competition, misuse, antitrust. None of that's changed, but what AI has done is it's moved the boundary line of some of those properties, which you need to be aware of, because depending on which side of the boundary line you're now in, you may have compromised your ability to get protection in these areas. So let me rifle through at a high level some of the intellectual property basics. We start with a patent. A patent is an invention. There's three forms of patents. There's a utility patent, which is a patent on function. It's things like a device has elements A, B, and C. A process has method steps A, B, and C. It's also a composition or article of manufacture. Another form of intellectual property, of patent protection, is a design patent, which protects an ornamental feature. It's sort of the skin look and feel of a product. And the third form of patent is a plant patent, which protects asexually reproduced plants that you can get patents on. I've had the opportunity to walk through the fairgrounds to see a number of the exhibits, very impressive exhibits indeed. And I would say that most of what I've seen would be fertile grounds for utility patent protection. There's a lot of steps on, a lot of patents, a lot of inventions on methodologies for DNA, for enzymes, and also devices such as a ski device with shock absorption capabilities. To give you an idea of some types of patents, there's a patent by Wright Brothers here. The patent was ailerons, these things left and right part of the wings. Up until then, the aviation had rudders and flaps, but they didn't have the ailerons. It's really the ailerons that allowed the Wright brothers to actually be the first to fly. There's the Wright is an electrical patent. It's an optical device. It's hard for me to see. Basically, you put the package in front of the optical device, which locks in an alarm, which, if the package is removed, triggers the alarm unless the alarm is disarmed. Here's a patent on a cancer detection involving putting a contact sample in an immunoassay with antibodies that bind to markers and then detecting the markers. To the right is a patent on putting electronics within the skin to allow you to do computing actually on your body. In the world of design patents, we have probably one of the most famous ones is the Apple iPhone. It's the ornamental feature of the phone. Interestingly, Apple had a hard-fought battle with Samsung for a number of years that was settled, I think, 2 or 3 years ago. There was maybe 11 utility patents in the fight, Apple utility patents in the fight. There were I believe there were 2 design patents. And interestingly, when you finally came to damages, the patents that created the greatest return for Apple were these design patents. These were the ones that Apple won the most damages on. But even more interesting than that is, and this speaks to the power and importance of a patent, was for Apple, it was maybe 300 million, I don't remember the exact number, I mean a large number, but to Apple it's like pittance. But for them, the real win was getting the injunction to shut down this technology for Samsung, because it really spooked Samsung, made them look behind their back, and the result was Apple gained 2 or 3 points of market share, which translates to billions. So that was the real big win for Apple using these design patents. On the right, we have the Bartoli Statue of Liberty design, well known. Next slide shows plant patents, a plant patent. It's an asexually reproduced plant that you can get patents on. I didn't see any plant inventions in exhibits that I've seen, but there is patent protection available for plants. Let's turn to the next bucket of intellectual property, which is copyrights. Copyright is an artistic expression. It's expressing ideas in a form that's fixed in a tangible medium, and what that means is it's fixed to some medium that allows the expression to remain over a period of time. That can be in the form of a book. It can be a book, it can be movies, TVs, it can be albums. We have lower right, we have software. The medium there is the magnetic medium that the code is held in. We've got drawings. We've got the sculpture here. You can see it's the medium there is the material it's made from that carries that artistic expression over time. The next bucket of intellectual property is trademarks. The trademark is a mark attached to a product, a good. The corollary of that is a service mark, which is a mark that it's attached to a service. In either case, the purpose of the mark is that when people see the mark on the good or the service, they immediately associate that good or service with a source. The source, the provider of the good or the service. And the value of the trademark is people recognizing the source of the good as being a high quality source or a not so high quality source. A great example is if you're thirsting for a cola drink, you go into a mom and pop store and you go to the cola shelf and you see a can of Coca-Cola and you see a can of Mom and Pop's Cola. Well, when you buy that Coca-Cola, you know it comes from Coca-Cola. You know what it tastes like, you know the quality, you know what you're going to get. When you buy Mom and Pop's Cola, you're not sure what you're going to get. So the value of the trademark is the strength of association of the consumer with the source and the quality of that product from that source. Some illustrative marks, well known. Coca-Cola, of course. There's Apple, Google. I've been doing this for many, many years. 10, 20 years ago, maybe, this was the #1 recognized trademark in the world. Today, probably last year it was this. Today it's probably this. We also have service marks over here, the American Airlines and Starbucks. Another form of IP is a trade dress. It's basically a skin of a product that is sort of a cousin of a trademark in the sense that its value is people recognizing who the source of that dress is. In the case of the first, it's Coca-Cola. In the case of Jif, it's whoever makes Jiffy peanut butter. And again, the value of it is like a trademark, is people know what you're going to get when you buy that product because you know that product has a certain quality because you know the source of that product delivers that kind of quality. And on the far right, again, is another Apple device, iPhone. There are other forms of intellectual property that we'll just touch on very quickly. They include trade secrets, which is confidential information that gives you a competitive advantage. There is unfair competition, which is being truthful in the conduct of your business. Are you lying about your product, what your product can do? Are you lying about what the other competitor's product is doing and what it can do? Things of that sort. And data also is fertile grounds for intellectual property protection. It raises all sorts of issues like privacy, especially important in the medical and HIPAA. So those is sort of a quick run through of intellectual property. There's important to know who is the inventor or creator in all but patents. In the case of the patents, the inventor is one who contributes to the conception. Earlier I gave the example of a utility patent which has elements A, B, and C. In order to be an inventor, you have to have contributed to one of those three elements, which ultimately were judged for patentability and allowed for patentability. You need to contribute to one of those elements. If you're not an inventor. And that's even if you're not participating in actually making the model or the write-up of it. It's known as reduction practice. In all three other instances of in all three other instances of IP, the creator is the one who actually creates the copyright, creates the trademark, generates the trade secret. And finally, before we turn to AI, we have a fundamental overview of relationships that you're going to have in the workplace. On one end of that spectrum is the independent consultant, on the other end is the employee. Employee is someone that's working for an entity, a company, could be for another person. The other person could have the company, and this person is working for it as an or her as an employee. And on the other end of the spectrum is the independent consultant. They're the ones who provide specialty services, like law firms that provide services to clients. Who owns the inventions and intellectual property depends on the relationship. Traditionally, employees have what's known as a work-for-hire provision in their contract, which means that everything the employee does, creates, all the inventions belong to the company. At least a good company will have a good agreement with the work-for-hire assignment to the employer as to inventions. But of course, you could have an employee agreement where there's a carve-out of that work-for-hire, but generally, employees are work-for-hire. On the other end of the spectrum, it depends on what the independent consultant's contract says. So if you're doing coding or some sculpting or artwork for another person, whether you're going to own that work product, the intellectual property of that, or it's going to be owned by the sponsor, is going to depend on whether there's this work-for-hire provision. And generally what happens is with the independent contractor, a good contract for the buyer would be to have the a work-for-hire provision in the independent contract so that the intellectual property goes to the sponsor and not just the final work product, but the actual intellectual property for that. As Dr. Bauer mentioned, all of this is covered in great detail in last year's talk, so if you want a more robust run-through of all this, please take a look at that. So let's look at how AI has done to change the intellectual property protection. As I mentioned earlier, what AI has done, it's not changed the protection, but rather it's moved the boundary line of that protection. So we're going to look first at copyrights. Okay. So with copyrights, the seminal case is this Thaler v. Perlmutter. She used to be the director of copyrights. He created this AI model, and he instructed that model to generate an image, which he then sought to copyright protect. And the Copyright Office refused to protect it because in the copyright application, the creator of that image was listed as this AI model, and the examiner refused to grant the copyright because on reading the statute required a human element contribution to that artistic expression. Thaler appealed it to the Federal Circuit and appealed all the way to the Supreme Court. The Supreme Court denied hearing it. So the law is the law, and the law is basically that if you want to have copyright protection, you need to have human authorship. You need to have some human component to the final work product. And not only that, but the scope of copyright protection is going to be limited to the human contribution. So if you're using an AI text for work or for yourself, or generate an image or a marketing slogan or whatever, you need to be careful how much you input. The more you can input into the ultimate output, the more copyright protection would be available to you. And that's significant because The name of the game in copyrights is to put as much distance between your copyrighted work, should you get a copyright, and the copyrighted work of others. So if you have an example here, a 50-page report that's going to be copyrighted because it's an expression and it's fixed on the paper and it's created the instant you put the pen to paper. So you have a copyright in that, but if 90% of that work, that report, is created by AI, then guess what? 90% of that report is not going to be copyright protected, which means that the only distance you're going to put between your report, the copyright in your report, and the copyrights of others is the 10% that you contributed. So it's really important that you be mindful of your contributions that you're making to artistic expression, because it's only those contributions that are going to be ultimately entitled to a copyright. Important in everything we talk about today is documenting your work. It's important to keep a paper trail. When you use AI, you have this prompt. We're going to talk more about prompts a little bit later. Very important. But you have this prompt that you input instructions for the AI to execute. And it's important that you document that whole procedure. When I use AI models, I always copy the questions, instructions that I put into, that I'm asking AI to output for me. I copy that in a Word document, and then I push the button to have AI do its thing, and then I copy the output that AI has generated, and I paste that underneath the question. And then, of course, AI comes back and asks more questions. Do you want to do this? Do you want to do that? And every one of those, every one of the new questions that I ask, I put into my Word document, and every new answer I put. The whole idea being that I have a documented summary of the whole creative process. So should I decide to file for a copyright registration, the same goes for patents, I have some documentation to say, okay, based on this documents, this is what I contributed, and that's why I should be entitled to a copyright or a patent. We're going to talk about patents in a minute, but it's the same concept, the importance of keeping patent trails. There's a bullet on this slide that talks about work for hire. We talked about that before. Work for hire means that your boss, your company, or if you're a consultant, the sponsor of your work is going to be owning your work product. One of the areas of AI litigation with respect to intellectual property that has been the greatest, it's been in the copyright area, it's been with respect to AI. Because the way AI works is a two-step process. It does this training step, and then it does this rendering step. In the training step, you have all these neural devices that are in this network, and this neural device basically looks through the universe, captures all the information it can from whatever it can get its hands on, let's call it the universe, and it trains itself so that it can recognize in its locality that each neural device operates in, it's going to recognize a pattern that it's supposed to recognize for that locality. And that's how AI works. It's based on pattern recognition. So you have the first step where this training, this network is like looking at every copyrighted work out there and everything that's out there, every image, everything, and it's just putting it, it's training, it's putting its memory bank. So needless to say, many authors, the Actors Guild, every creative person that has some significant stake in own copyright ownership has complained that AI is, without our permission, AI is training itself. And that's led to many, many lawsuits throughout America. And fortunately, there's starting to be a little bit of daylight as to where the courts are going to come out, and there have been some cases that have been decided that I think provide good guidelines. And the case that is important is one that it's a Supreme Court decision that enunciated 4 factors for determining whether the copying of a copyrighted work is going to be a fair use or whether it's a copyright infringement. these are the 4 points, and they're effectively the purpose and character of the use, the nature of the copyright work, which is it for profit, non-profit type of thing, education or not, the amount of substantiality, how much you've taken. In the case of AI, they take it all, they train it all, they copy it all. The effective use upon the potential market. So here's where AI had the factor favors AI, because what AI does with this is it makes this work even more accessible to the public. It's just, you're able to search and find things that you probably never would have found without AI. But the real factor that decided a case, it's a guiding case that was handed out of the Northern District of California, is this factor here, because this factor through judicial prudence has evolved into what's called transformative use. And the case is best exampled in this Google, the Artists Guild versus Google. And it's a case dealing with snippets. It came from New York, and it ultimately was affirmed on appeal. And basically, what Google did is it created a library of all this catalogs of books, and it scanned all these books, and it created this index. And then what it did is it would take snippets of the book. So when you search for a particular book, it would bring up like an index card with some information, and it would also bring up, you could look at like page 1, you could look at a couple paragraphs of page 1 and maybe page 5, and they call them snippets. So you can't read the whole book, but you can read bits and pieces. And the court said, hey, that's transformative, because without it, we would never have been able to do that. We wouldn't even know about half the books that are out there. Nobody knows about them. But now, through Google search, using these snippets, you do. And that was a transformative use. In the case of AI, the training is viewed as a transformative use. I think that's the leading decisions of the courts right now, is that the copy, the training piece of AI, that's a transformative use. But that leaves the question of the second function that AI does, first function being the training, the second function being the rendering, which is displaying the results of your search. That's the area where AI is getting tripped up. And a great example there is this case, I don't know if I can. Disney Enterprise, it's out there kind of where I pointed the laser. That case involved doing a search of a Darth Vader-like character where you describe a person in black outfit, and Darth Vader, I think, was used. And guess what? The result was Darth Vader was Disney's Darth Vader character. And so Disney sued, and it wasn't just Darth Vader, it was a number of others. But here, the rendering, which is a publication, and that's the thing that the copyright is trying to protect, that rendering was deemed to be infringement, and this company, Midjourney, they ended up, this particular case, I believe, was settled because of that. To me, I think the way AI is going to deal with that, because that's an issue with every output that AI produces, renders, is whether that's identical or substantially identical to somebody's copyrighted work. But I think AI will solve that, because AI works with layers of these neural devices, and all you have to do is put a layer of neural devices that actually matches the output that AI would like to render, and matches it against exact or substantially identical matches it against exact copies, and it makes a determination, is that exact or substantially identical? And if it is, then maybe the resultant output is going to be, we can't give you an answer because that's copyright infringement. But if it's not, it can render the decision. So I think AI is going to overcome copyright infringement issues, and it's just a matter of the user who is putting in the instructions being knowledgeable that they shouldn't put confidential information in there, especially if it's a public model, AI model. They should document all their work. They should be mindful that the more the human contributes, the more the copyright protection will be. Keeping those things in mind, and I think the AI becomes a very powerful tool. patents and AI, the boundary line has also changed a bit. So we have again Thaler, Dr. Thaler. He used his AI model to create two new inventions. One was directed to a light beacon, another to a food container, and he filed for patent applications on these. And guess what? He listed the inventor as being the AI model. Well, the outcome with these patent filings was no different than his copyright filings, because the examiner said, hey, wait a minute, there's no human contribution here, so you're not entitled to a patent under the laws. It went up to the Federal Circuit, which affirmed, and the Patent Office has given guidance here on the importance of the human contribution, that simply putting questions into prompts is not enough. There's got to be some creativity in that, or inventiveness in the case of patents, but same issue goes for copyright. So there's got to be creativeness in the instructions you're creating. If you're looking at the AI model, the ultimate output with your questions and the answers as being potentially copyrightable. And according to the Patent Office, the AI should be viewed as nothing more than a tool, but a very powerful tool at that. Trade secrets were challenged by AI in a case just this February, where a person that was accused of a crime, so it's a criminal action, that person ended up using a public AI model to do his case write-up and his defenses and document what he did and stuff. And of course the prosecutor wanted to get discovery of all that. The attorneys objected. And he went to the court, and the court said, well, you know what? You took no measures to keep this stuff confidential. So it's public information. You put it on a public AI, so it's publicly available, and the prosecutors got all of that information. The important lesson with trade secrets is that when you use the prompts for AI models, that you be especially mindful. First of all, if you're using a public AI model, never put confidential information, because that's going to go into the universe of ecosystems that the AI trains on, and it's not going to be no longer protected. And secondly, you should, if you're using one of these enterprise models like Gemini or ChatGPT, you should be mindful of their rules on what is confidential, what's maintained confidential. And as a general rule, it's probably good not to put confidential information in these queries, these prompts. Definitely though, if you're going to use AI, using an enterprise AI is the best strategy to take. So let's look at how AI has affected trademarks. So here, surprisingly, AI has had very little effect on the protectability of trademark. And if anything, it's just created even more value in trademarks, because AI as a tool for designing trademarks is simply amazing. And you may ask yourself, so why is that? And the answer is because whereas patents and copyright laws seek to protect human innovation, human creativity, trademark laws don't reward human contribution. What they're rewarding is the strength of the association of a mark to a source of good. That's what a trademark or service mark is all about. And that's why AI hasn't changed the playing field with trademarks. But that said, AI does introduce heightened risk in your trademark outputs from AI, because AI is going to be scraping its database, what it has trained on. And it's going to have all these trademarks of these other companies as part of its trained database. And so you need to be particularly careful that the output that you like as a trademark, that's not going to violate, infringe the trademarks of a third party. So if anything, what AI has done, it's not limited protection, but it should make you especially wary of your output. Is it going to infringe other people's trademarks, which means that it's probably a good reason to make trademark clearance work an important part of your practice, so that whatever output, trademark output you get from AI, it's cleared with respect to third-party trademarks. There's a couple other areas of IP that AI has affected. This one is unfair competition, AI washing. We talked about unfair competition as it's being deceptive in your business practice. It's telling lies about your product, telling lies about your other companies. You have to be careful if you're doing comparatives of your product with using AI of competitors' products. You have to be careful that the output of AI is not somehow made statements about the competitor's product that are not entirely true, and the same goes for statements about your product. So there's an important need for an integrity check in the output and validating the output. There's also a thing about shadow humans that, I don't know, you get on a phone and there's an answering person and the person talks, and at some point you start to think, this doesn't sound like a real person. Maybe you don't answer or something, and then the person starts saying some stuff that tells you that it's really AI. Well, that you have to be careful, because if people believe that it's a human that they're interacting with and it's not, that can be a deceptive practice. I think at this point it's probably worth me relating a sort of an anecdote from my practice. I had, and this is my view of AI, and I'm going to come back to this and close out on this, but this is my overall take on AI. I had a paralegal. We had a paralegal in our office who was going through, we're working on her college degree, and she was asking me, looked at me as a mentor, she was asking me what do I recommend would be a good degree for her to get into. This was 10 years ago. In 10 years, there's no question in my mind that the degree to go into for somebody that's technically inclined would be computer software engineering. Because if you have the skill set developed to be able to write code, that's invaluable. You could write code, any company needs it. You can even write it out of your home. It's an invaluable skill. Well, if someone were to ask me today what degree they should get, this would be my answer. My answer would be, and you're gonna see this once we get into the area of prompts. My answer today is that you should get a professional degree to develop competence in an area that you're passionate about, be it engineering or law or medicine, accounting, be it art, history, politics, whatever. Just get really good at it. That's number one. But number two is do a minor in communication or English, because when I get to the area of prompts, you're going to see that the people that are going to win and rise to the top in the command of AI are going to be the people that communicate effectively. They can write very effective prompts, instructions, and secondly, they have the competency to be able to integrity check and validate the output. And I've got some examples I'm going to talk to at the end of this talk that shows you how you can run afoul if you don't have the competence, but you don't have the right communication skills to ask the right questions. This next slide I think is really interesting because it talks about antitrust. I mean, who would figure AI would have an effect on antitrust? But one of the fundamental violations of antitrust law is collusion in setting a price. When two competitors get together and they say, okay, let's set our price at this price point. Well, that's a per se antitrust violation. Well, nowadays, you've got competitors doing it. You can basically have AI pull together information that's borderline. It's not collusion, but it's starting to get there. And this is an area that the Justice Department is starting to pay more attention to, because prices are not floating as they would based on individuals, but starting to float according to sort of outputs that AI generates based on similarly posed questions by competitors. So that's an area that AI is definitely impacting. There is California. We're going to talk a little bit about laws that are evolving to deal with some of the AI problems, but one of the laws is in California, where they actually have a criminal statute that prevents an entity from using soft commands that actually give you similar prices for different similar commands. It's like aligning prices among there's software that does that, and California makes that a crime. The last bullet on this slide talks about data moats. This is something, if you've ever followed Warren Buffett, he talks a lot about stocks. He's Berkshire Hathaway portfolio of instruments of stocks. And one of his big repeating messages is that I like companies that have moats around them. So Apple is a great company with moats because it's got this ecosystem that nobody can penetrate. They have to pay 30% of their revenues to be able to be an app on the system. And Buffett likes that. So, but this is an area that, in terms of antitrust, is rising greater importance among the Justice Department. In fact, there was a case involving Google where Google paid Apple $50 billion annually to have their Google browser appear on the display of an iPhone, and that was challenged by the Justice Department. And Justice Department actually won the case, but then the court was deciding what the remedy is, and I don't think the court was that worried about the price for what Apple was going to do for them, because that's ultimately a contract, and it would be up to Congress to legislate if that's prohibited. But what the court was worried about is this data moat that Google has created around themselves. And in fact, the remedy that the judge rendered in that case had, in my recollection, had nothing to do with the $50 billion price, but it had to do with Google opening up some of its data banks, some of its moat, making some of its moats passable for some of its competitors, so that some of the competitors can compete on more equal footing with Google. Google has appealed that decision. Another area that AI is affecting is misuse, privacy, and data. It's no defense to a problem with an AI output that AI did it and I didn't do it. A user is entirely responsible for the output of the AI. Courts are developing their own policies on the judicial precedent on dealing with wrongfully scraped copyrighted material that ends up in product. And a good example is this right to deletion. There are a number of courts that, if a product is found to contain unauthorized code, they will require the producer of that product to disgorge that code from the product, which is pretty much can be a death knell for product. It's definitely it may lead to recalls, it may require redesign and reflashing of the code. But it should create a special importance that you validate the output of AI. And why is AI in the factor? Because, as I mentioned earlier, Google has this app that it runs on AI that allows coders now to put instructions, AI instructions, to do the coding. We have a client who fired his software coding engineer and replaced it with the heads of the department actually putting in instructions in the prompt to generate the code. I mean, that's kind of where this is all going. There's certain things like software, it's becoming commoditized because AI can do it better. But there's other things, as I mentioned with my mentoring suggestion for today as opposed to 10 years ago. 10 years ago with software. Today is getting a degree in something you're passionate about, so develop competence in something you're passionate about, so you can integrity check and validate more, but also developing communication skills so you can do prompts effectively. I think that's where the name of the game is today. The ability to integrity check and keep unauthorized code from being blown into your products is the important example, in this case, of disgorgement. In the area of data, there's this whole HIPAA thing that it hasn't been changed, but it should make people even more cautious about putting any private data, any medical data into an AI model. Dr. Bauer mentioned in his introduction reference to Val Kilmer, so I thought that I can talk a little bit about what that was about. So Val Kilmer, I think everybody knows who he is. He was in the Top Gun, he was in Tombstone, also Batman, and he developed throat cancer and passed away, I think, last year. Well, there was a director who made a movie entirely around him. They scripted the movie, they were ready to roll the camera. Unfortunately, Val Kilmer was quite ill and was unable to perform, and then he died. But the director didn't give up because he really felt Val Kilmer was the best person to play that role. So the director wanted to use the image and the voice of Val Kilmer, and basically what they would do is they would have somebody else against a green screen create the poses, and then they would superimpose Val Kilmer's image and then superimpose his voice on top of that. That was sort of what was going to happen. And lo and behold, the estate, which now held all of the assets that, the estate of Val Kilmer on his passing, the estate held all those assets. And these assets are, there's a laundry list here of what those assets are, or what they include. It's the privacy of the voice, the image, copyrighted trademarks, published works, unpublished works, and so on. The estate actually gave permission to the director to use Val Kilmer's image, to use his voice in this movie only, in exchange for some compensation. And, they did it because they felt it would be nice to see their dad again, and they had all these reasons. But the point is that AI can use images of actors, or of anyone, of you and me. They can use our voices, but only if they have permission from whoever owns those assets. So in each of our case, they would need our permission to be able to do that. For someone who's deceased, they would need the permission of the estate or whoever the estate has sold the property to, the asset to. And if it's not owned by anyone and it's public domain, then have at it. Interestingly, Val Kilmer's not the first case that dealt with this issue, because when Robin Williams died, he had some pretty smart attorneys who basically wrote into his will for his estate to not use his voice and image for 25 years after his death. So it's something that ends up in a will. It's something that the attorneys, good attorneys, are mindful of, but it's something that's interesting to know about, because we're going to see more of that kind of thing. And in fact, that was one of the big reasons for the actors and Screen Guild strike a couple of years ago, was AI's use of images of actors and actresses without their permission. I'm going to rifle through some general rules on good AI use practice, and then I'm going to turn the rest of the presentation time to talking about prompts, because that's really the new world for intellectual property protection. So some default rules for whether you're an employer or an employee: be mindful of work for hire. We've talked about that already. Look at the agreements that you have for AI provisions, especially the work for hire, because Whatever you do under an employment agreement is going to be owned by your employer. For an independent contractor, it depends whether you have that provision in your contract. Personal projects, there are some employees who get frustrated using enterprise databases, AI databases, and they end up switching to their personal databases, some of which are public. It's a huge problem because it may not only violate the policy of the company to use the company's enterprise AI model, but it also creates a problem if it's public, then whatever you're doing there using company information could become publicly disclosed. You might breach confidential obligations, and the problem, and then there's the question of how much human involvement for purposes of copyright and patent protection, a whole host of problems. So be mindful of the policies of the company you're doing work for, and use your personal AI stuff for your personal projects, but not for company work. I've got a couple of illustrative AI cases. I won't spend a lot of time, but it's kind of good for you to be kind of aware as you move into your professional careers and you're going to be dealing with these kind of contracts. But there's an assignment provision as number one. It's who owns the outputs. That's something that you should be a little bit familiar with. It's going to pop up. Number two is significant contribution. I think a good employer or someone who's paying a consultant for a work for hire arrangement would want to ensure in a contract that the person doing the work is significantly contributing, especially if the employer or the owner paying for the work has some expectation of good copyright or patent protection from it. There's this model versus output distinction. Typically models are owned by the provider, whereas the outputs are owned by the employer or the sponsor of the work. Number four is transparency disclosure. This is something you should expect to see companies asking you to declare that you're going to disclose any content that's generated by AI. There's this, number five is data provenance and clean training. It has to deal with warranty that if you're an independent contractor and putting it in the code, you're going to warrant to the sponsor who bought the code that you've not scraped unauthorized code into the code, that you've done an integrity check and validated. These are sort of typical provisions you can expect to see. Again, I don't want to belabor this point, but it's kind of good to have some familiarity. Number six is important. We talked about how, well, laws are still slow in coming, and we're going to talk about that in just a minute, what the laws are. The courts who are faced with these problems are forming judicial doctrines to kind of deal with some problems. And one of the doctrines I talked about is disgorgement, which could be fatal to a product if it contains unauthorized code that was scraped by AI and not caught by the programmer. So 6 is a provision that basically puts liability on the coder. And then 7 is the HIPAA type of stuff. Not using private stuff on prompt portals. So now I want to turn to what I find to be the most exciting and fertile grounds for AI innovation and protection going forward, and that's prompt engineering. So what is a prompt? A prompt is basically an instruction or a question that you put into a window once you bring up your AI model platform to have AI do some stuff for you. So when you open like Gemini will open up, and then there will be a window that'll pop up, and it's a search window. It's kind of like the Google search windows, but it's a search window to let you reach into the AI, and that window is where you tell AI what you want done, and based on what you instruct AI to do, it's going to give you an output. So I'm going to give you a couple of examples to show you how it works, but I think it's very helpful to look at this table that I've put together over here. This table, I think, you should probably study it, because this, I think, is the evolution of coding. When I went to engineering school, we had to learn assembler language, which is called like a low-level language because you're real close to the registers and the CPU, and you got these real archaic instructions that only these super smart guys could ever figure out. I was never good at it. But that was a fundamental part of early coding. And then, over the last 20 years, there was this new code developed. I call it middle layer. And this middle layer is, I think it's right there. It's C code. You're probably, if you've done any coding, you're probably familiar with C code. If you look at the example on the right, the C code, it has instructions like int x equal 5, y equals t. I mean, there's instructions that start to sound like English, but it's still a little bit obtuse unless you're super into this kind of stuff. Certainly easier to understand than look at the lower level language, mov ex5, mov ebx10, right? But now look at the highest level here. Highest level here. Guess what that coding language is? English language, or Spanish language, or whichever language you're using, you're creating your instructions for the AI model to operate. And I'm saying, yes, today's coding is that instruction set. It's the instructions that you create for AI. That's the new code, because based on that instruction, and it's very understandable, based on that instruction, AI is going to configure itself to give you the result. I mean, before with assembler, you had to tell it, move this thing to this register, move this to that. You had to tell it step by step. I mean, today, all you do is you tell the AI what you want, and voila, AI gives you the output. So let's look at a couple of examples. I have an example of a simple prompt. So this is on the left. You decide you want to raise. So this is what you tell AI. And you push the enter button, and AI does its magic, and it comes out with this. Well, you can see there's a lot of bracketed information there because you didn't give it a lot of information to work on. But right away you can see, wow, with just a simple command, write me an email asking my boss for a raise, AI generated an entire letter for my boss. So, what happens if you ask a really good question and give the AI enough details to really give you a robust letter? And that's the second example here, where you have, I call it the optimized prompt, and I have these different bullets, but there's no magical formula that you have to use. It's basically, as I said before, it's effective communications, knowing what you want AI to output and being able to effectively write that command. But if you can do that, and here's an example where, in the same example, I'm asking my boss for a raise, I'm telling AI, I want to act as an expert senior coach with 20 years. I need you to write a confident, persuasive thing, giving me a 10% raise, 90 grand. And then the third bullet is, these are all the things that I've done, and formatted in a standard professional format. And voila, look what you got on the right. Pretty good stuff, huh? So now, this thing in the prompt, this is the stuff that's potentially copyrightable. If there's an invention here, it's potentially, this is the human contribution to this overall output. This output here is going to be devoid of it, except to the extent that it's pulling your human contribution into here. So it's important to realize this right here is the new frontier for AI protection. It's putting together effective instruction sets, be it a copyright, artistic expression, it's a copyright, would be it invention. I want you to, I have an invention, element A, B, and C, and of course, in this case, you want to do enterprise, so it's not public. But I have this product in mind, it's element A. This right here is the human input, and this right here, output, is what may not be protectable, except to the extent that it sort of captures what you articulated here. So prompt engineering is extremely important. tell you enough how important it is. And I'm going to show you another slide, and I would say, if anything, the slide that I showed previously about the different levels of language, and the next slide I'm going to show you, I mean, those are things you probably want to print out and have available. I think it's very insightful on the power of AI. So this next slide, this is a drawing I took from John Huang Enterprise. There's the author of that. And what he's showing is transformation. This is of AI models from 2023 to 25, just 2 years. He's showing what the makeup of the coding output was in 23 compared to what it is today. And guess what? In 23 you had a lot of coding here. I think that's coding. You have a lot of coding here, but guess what? Look at the coding over here, it's kind of diminished. This is the actual code that the software programmers, software coding is becoming a commoditized practice because AI can do it. And just as importantly, the data is similar, right? Same type of shape. The model has gone from a bigger to a smaller one, but the significant thing is the prompt. I mean, look at the prominence of the prompt in the value of these apps. I mean, it's huge. It's become the dominant one. And again, it just sort of underscores that these prompts are becoming the value drivers of future IP. Remember again that with prompts, on the right here, you need to be mindful of trade secrets, because what you put on these prompts, there is always a potential that they could be disclosed. Even with an enterprise, you need to check the rules of the enterprise. The ownership, you need to be mindful of the work for hire. And keep in mind that if you're doing this stuff for your employer, all this output from the previous prompts, that's all going to be owned by the employer. But the skill that you have and you develop and you will be developing, that's something that stays with you forever. They call it residual skill, residual edge, that stays with you. So you can't take the AI outputs that you've done for a company, but you can sure take sort of the skill that you develop from doing all this AI work for the employer. Again, I think that's really the new frontier for IP. The next slide talks a little bit about infringement. There's always the risk of unauthorized output in your outputs. It's important to do the integrity check. I have on the second bullet the Disney case cited again. I think it's over there, and that's a great example where you need to integrity check that, because that is an infringement. The Darth Vader. Accidental plagiarism is not a defense. We mentioned that before. And also keep in mind with when you have an enterprise AI, there may be some provisions that give you some protection if there's a screw up and AI accidentally releases it and puts it into the universe of training. But if it's a public AI system that you're using, you got no protection at all. So especially just be wary of the public AI, and just only use it for stuff that is not confidential, and it's not, it's not competitive stuff, and it's not in your invention. So just be mindful of that. I'm going to talk a little bit about the compliance landscape. Most of the stuff that I've talked about is stuff that's happened just this last year. I mean, it's just all over the place. But fortunately, courts are starting to put some guidelines in place on how to deal with this. Unfortunately, legislatures are still struggling with catching up. Colorado and Texas have statutes. The president is trying to get a policy that preempts all that. The important thing is that in all of these statutes, there's a requirement that high-risk decisions very important decisions cannot be made by AI. And there's an example I'm going to give you where an evaluation was done by AI, a performance evaluation of an employee, and that was problematic and wrong. There's these statutes, they also require transparency notices that if you're dealing with an AI thing, there should be some notice that that's what you're dealing with. There's also bans on use of AI in certain contexts. So slowly the legislature is catching up. So quick checklist, maintain a logbook of your AI prompt work as well as the outputs so you can document human contribution. The last point is use policy, and to develop an acceptable use policy. Individuals may say, well, I don't have to do that, that's what companies do, but actually I put to you that you should personally develop your own use policy on how to deal with AI, that you document your questions, you document all of the output, you just document everything, you use enterprise only, you try to stay away from confidential work. The things that I've been talking about, that can create this use policy for you, and you should, on the second bullet, you should periodically audit yourself, ask yourself, am I doing this? I need to make sure that I'm copying this to document my work, that the AI enterprise that I'm using has this confidentiality, so some of the stuff I'm putting in there is not going to be breached. Getting near the end, and then we'll give you a couple case examples and open it up for questions. There's an issue with ethical use and shadow AI. Shadow AI is when you're using your own personal AI instead of the company's. We sort of talked about that before. There's the vicarious liability that you can't blame the AI tool. It's up to the user to validate integrity check it. Here's another quick checklist. Separate the enterprise from your personal. Maintain the human trail. When you're using prompts, if you have to get into some confidential stuff, maybe if you can anonymize it, so kind of minimize the confidentiality that creeps into your instructions. Very important to review your contracts. We have another slide on the future. It's very similar. Separation of AI tools. Importance for human contribution for copyrights and patents, and confidentiality is lost with the public, and make sure you don't violate company AI policy. So now let me run through 4 quick examples to show you how AI can blow up in your face. So the first example, you have an employee who was tasked with coming up with a campaign slogan for a new product. It's an unreleased product, no patent's been filed on it, and the employee says, hey, you know what, I'm gonna load this stuff into AI and have AI output this killer script, killer slogan. So this employee ends up inputting the entire spec, unprotected, unpatented, not patent filed spec of this new product, and he also input the top 500 loyal companies of the customers of the company. Why did he do this? Effectively, in the marketing area, it's a lot about focus groups and what do people of this type of group, what kind of thing do they like to see? So what this employee was trying to see is, what do my 500 customers like to see in a product? And really, we're going to focus on a slogan marketing campaign that's targeted to that. So, AI did, you hit the enter key, and AI did its magic and came up with this killer script and killer slogan. Everything was terrific until the company went to file for patent protection, and then lo and behold, we can't get any foreign protection because everything's already part of the public domain, because this guy used his, he didn't use enterprise, he used public. It's all part of the public domain, so you got the companies like angry as heck because we lost foreign protection, clock's starting to run on US protection, and all of their customer list is now publicly available, so the competitive advantage that the company had no longer exists. This employee violated the policy of the company, host of problems. I think it's a great example kind of underscores some stuff to keep in mind when using AI. Second case study is a computer software programmer. So here's a guy whose boss tells him, okay, I want you to develop a code to do this. And so the coder says, well, I'm going to use AI to do it. I don't need to spend a week doing this. I'll have AI kick it out in a day. So he gets on AI and he starts giving the instructions to AI to put together the code. And AI puts together a killer code. And this code gets blown into the products of the company and the products gets released. But guess what? The code included some unauthorized code where permission was not obtained from the owners of the code. So now there's a big problem because the company has introduced all these products with unauthorized code. So not only does the company face a lawsuit and damages, but under court precedent, there's a likelihood of disgorgement, meaning that the company's going to have to recall its products and develop new code and flash new code into this product. Huge mess, and it's one that would be avoided if the employee did a proper integrity check to ensure the validity of the code. And that's where, and this is a point I've mentioned a couple times, and it's my mentoring expertise to those starting out who are looking for my guidance on what to, how to guide their career. I would say, get really good at something. Get a degree, a professional degree in something. Whether it's history or art or engineering or whatever, just get really good at it. And secondly, do the minor in communication so you get really good at communicating, because the winners of the AI game are going to be those that can communicate effectively and have the expertise that they can look at the output and validate that it's correct. If this programmer had the expertise to know that the code that was output by AI was restricted code, this problem of this second case study would never have happened. Third case study is one where a high-performance employee spends a half year developing a killer AI output that tracks it's a way for rolling up the quarterly reports for its company. 6 months of work, you can imagine, a lot of instructions. It's just like an excellent model, which probably is protectable as a copyright, and if there's something invented there, maybe as a patent. And under work for hire would be owned by the employer. But this employee is a high-performance person, ended up getting a better job somewhere else, so he thinks, I'm going to take this with me. And he ends up deleting the code and taking it with him. And guess what? The next time the company's doing its quarterly report, hey, where's that killer app that generates all this stuff? It's not there, and then they do some due diligence and they find the guy that deleted it. This guy is not only in violation of the work for hire, in violation of the AI policy rules, but it's also, he's destroyed property of the company, which carries criminal charges. So another great example is just to think what the company owns belongs to the company, but your skill set in developing that output you carry with you to your future jobs. And the last case study has to deal with AI performance. Oops, that's the third one. Okay, this is the last one, AI performance. So at some point in your careers, you may end up supervising a number of employees, and part of a job of a manager is to evaluate the employees periodically, annually, quarterly, whatever the company policy requires. And that's a big job because you have to look at every employee, what the job requirement is, what was the employee supposed to do, what did the employee do, how good did the employee do, he or she do the job, and it goes on and on. I mean, these managers would spend, I've done this myself, you'd spend like weeks doing these evaluations for these people because you want to get it right, because this is important, this affects their career. So this manager decided, you know what, I'm going to have AI do it. So he input all the data on each employee, the work requirement, what the employee was supposed to do, what the employee did, how well. He inputted that for all the employees, hit the button, blah, blah, blah. All came out, results, maybe tweaked it with some additional questions, put it in a table or whatever so I can put it in a report to my boss. And lo and behold, one of the employees got such poor performance that he got a pink slip. And the employee said, "What? Let me see, where's my evaluation?" And it turns out the evaluation was done entirely by AI. And under the California, Texas, and Colorado statutes, that's forbidden. If a high-risk decision requires human involvement. So this employee effectively was wrongfully terminated and had a right to be heard by the human resources person in the company and whatever outcome that produced. So final slide is a quick Q&A that I put together. 3 short ones. What if I added 10% of an AI image, as I said earlier, with copyrights and patents? You want to put as much distance between that asset and the prior art or the prior other copyrights. And if you're only putting 10% in, that's not a heck of a lot of protection. So the more input you can make, the better. Second bullet, can you fire someone for using shadow AI? If it's a policy of the company, absolutely. And lastly, how do we improve human conception and patent? And as I've said before, document, document, document. So key takeaways is document your work, use enterprise and non-public AI platforms, review and abide by your contracts, increase your human involvement in your work so you put greater distance between your copyrights and patents with respect to what's out there. And then last, but again, most importantly, I've said this a couple times, get really good at communicating and develop a real good expertise so you ask the right questions and you can validate the output. So that concludes my presentation. Does anybody have any questions?
If you have any questions, I will bring the mic to you.
Firstly, thank you so much for this comprehensive presentation. I'm so grateful for that. My question is, if you are actually working on a provisional patent for projects like school projects or college projects, should we also be along documenting the prompts that we may be using to actually generate these AI artifacts as part of the application or the document? Should they be kind of kept as a copy that should be submitted along with the patent application? I just couldn't quite get, when you mentioned, just save these prompts on a Word document and keep it for a reference. Should they kind of become appendices of the patent application as part of it, or it is just like copies that we want to preserve just in case whenever any audit or something happens? And also, sorry, I mean, 2 words on my question itself, but whenever we kind of copy these prompts, these prompts or the answers from the AI doesn't necessarily give the timestamps or whatever data associated with it, and also there is not a clear evidence of which model and which specific version or any kind of the sort that we can get from the chat window. So what are your guidance to approach them and how to basically preserve them? My apologies for a very longer verbose question.
Okay, if I understand, there's 2 questions, and one question is, do documented prompts become part of your filed application? And the second question is how do you timestamp your documentation prompts? Is that correct? Are those the 2 questions?
Yes, that's
great. So the answer to the first question, do you append the documentation to an application? I would not. There's nothing that prevents you from doing that. I would not do it. The purpose of documentation is if you hit a home run on your patent and it ends up getting litigated and you're sitting across the table from the defendant's attorney who's asking you, what did you contribute to this invention, or what did you contribute to this copyright? The burden's going to be on you to prove what you contributed, and that's where your documentation becomes important. So I would not file it with your application, but I would definitely keep it in the file as evidence should you need to prove your contribution. And frankly, it can be posed by anyone. It's not, I gave you the worst case example where it's a litigation attorney, but it could even be, maybe the Copyright Office may ask you to document the human contribution. So I would keep it as documentation, but I wouldn't append it to any filing. So that's my answer to the first question. Does that answer your question on that one?
Yep.
Okay, on timestamping, I use Gemini, and you're right, I don't see a timestamp on there, but the whole idea is trustworthiness and reliability of records. If you have a lab book, if you're using a lab book, for instance, you should be dating the lab book, this is my work for today, and then you could put the copy and paste your prompts and the output into that lab book. So whatever you can do to increase the trustworthy and reliability of your prompts and the output, the better it is. So if you are challenged, you can say, this is what I did. It wasn't a timestamp on Gemini, but I put it into this document, and and this is it. It's documented. And in fact, you can even just put it in email. You can put the whole thing in email, send it to yourself, and the email will be timestamped. So there you go. That's one way to timestamp it. And again, the importance of this evidence is establishing trustworthiness and reliability. And however you do that is fine. There's no one required way to do it. Does that answer your question?
Yes, it did. Thank you. Thank you so much.
You're welcome.
Hi, thanks for the nice talk. I really enjoyed it. I'm a little new to all of this stuff, so do tell me if my question isn't exactly right or not. But going back to the case study number 4, say that the company was able to prove that there was somebody who checked the AI's work, like, okay, great, this makes sense, and they fired the employee because of that. What are the next steps for the employee? Would they still be able to win the case somehow, or is it just like over?
Okay, the speaker wasn't on so good, but I think I got the gist of it. So I think the question is if someone gets fired, then what can they do in connection with that to get a review? Is that kind of the question? Is that the question?
So if someone gets fired because of AI, what are their next steps?
Okay, that's a great question. Well, so one of the case studies that I put down involved an employee getting fired for low performance on a review that was done entirely by AI. And under Colorado and Texas statutes, that's prohibited. You can't have high-risk decisions made by AI alone. So the employee would probably hire an attorney, and the attorney would ask the question, who did the review? And if it's all AI, then pitch it. It gets pitched, and you can have the AI done by a human person. If it doesn't get pitched, a human needs to review it and sort of validate it. It's got to have a human oversight for those high-risk decisions. Does that answer your question? Thank you.
If you're fired and they said, oh, was it like you're in Atwell State, like Washington, they say, oh, you were fired and it was because of AI. Do they have to prove a negative that you weren't fired for an illegal reason? So let's say I have patients who have disabilities, and all of a sudden they're fired. And they said, well, because of AI, how can they prove that? Who has the rebuttable presumption there?
I think employees have certain rights depending on what state they're in. They have certain rights, and a lot of contracts are at-will contracts, but a lot of them are based on non-performance, not meeting the required levels of performance. And the more guidelines you can provide to establish that performance level, so that if an employee fails to meet that, it's grounds for firing, the better. But I think at the end of the day, if there's a firing that's based on the work product of AI, putting this firing report together, analysis of the employee and putting the report together, certainly under Texas and Colorado, that is a no-no, and I would guess that's kind of what many states would do. I think there is some fairness to employees. And that's notwithstanding, you can fire at will. It's just that the will of the company should be communicated by a human and not an AI. I think that's the point. Does that answer the question?
Yeah, it does.
Great.
Good second.
Hi, thank you so much for the presentation. This is awesome. Can you talk a little bit more about the third one, human consumption in a pattern? I know you had one slide where you talked about the prompt engineering part, but you talked about, the output is something you can't protect. And I know you talked about the prompt engineering part, like documenting it is the most important step. Can you also talk a little bit of why the output is not protectable?
Why, what is not? I think I got the first part, which is the conception piece of it, as it plays into a prompt, is that?
Yeah.
Okay.
I can't remember which slide it was, but maybe it was before the case study.
Yeah, I know which one it is. And then what's the second question?
The output, what is created with the prompt engineering.
Okay.
I think you mentioned that's something that cannot be patented.
It's whatever is not reflective of your work is what would not be patented. So, I'll give you, let me find the slide first. Okay, I think this is the slide you're talking about where we talk about conception, contribution to the conception, that makes you an inventor. I think that's the slide we're talking about. Let me just make sure I'm pointing it. Those two bullets, there's a conception reduction practice, and it's your contribution to conception that's key as determinative as to whether you're an inventor or not. And I gave as an example here, an example with the patent would be a product that has element A, element B, and element C. It's like a device comprising element A, B, and C. Okay, so in order to be an inventor, you would have to have contributed, if the patentability lies in elements B and C, not an A, then you would have had to contribute to elements B and C to be an inventor on that patent, okay? So if you put into a prompt, I am looking for this device to have this element A, but to be able to do some other stuff. And then AI comes back and says, oh, well, the device having elements A, B, and C can do that for you. So there you have an example where AI came up with elements B and C, and you only came up with element A, and in the example I just gave, patentability lies in B and C, so no patent because it's all AI, there's no human contribution. On the other hand, if in this example you came up with let's say elements A, B, and C are all patentable, or reasons for patentability, and you contributed element A, but your prompt to the AI was, I want a product with element A to be able to defy gravity, and then the AI tells you, oh, you need elements B and C to do that, so it's A, B, and C, right? And it turns out A is part of the patentability, so you're going to be listed on there as an inventor, and elements B and C were thought of by AI, so there's no reward, no patent reward for those elements. And the net is you effectively will get a patent, but it's only going to cover, really the scope of it is going to cover element A. You're going to have a patent, it's basically the claims to infringe, all your elements have to read on the product of an infringer, so a company has to have elements A, B, and C. But if in litigation, the attorney for the infringer says, well, what elements did you contribute? You know, suddenly your contribution is limited to element A, and that has decreased the value of the patent so that effectively B and C are in the public domain, and the only challenge that needs to be defeated is element A, and it's a weaker, suddenly becomes a weaker patent. That's kind of how it works. I don't know if that does answer your question. That's kind of how it works. I will say that if you write a prompt that says, I want a device with elements A, B, and C to be able to be usable in different contexts, and AI is going to take your elements A, B, and C, and it's going to work its magic and come up with different contexts. Even though elements A, B, and C now appear in the output, it's still in your instruction set. It's still stuff that you thought of. And in that sense, those elements remain patentable. Even though the output that AI generated, all this stuff around your elements A, B, and C are going to be public, non-protectable, because it's AI generated stuff. Does that answer your question?
Yeah, that was good. Thank you.
Great.
Hi, thank you so much for your wonderful presentation. I wanted to clarify a point on your slide about the golden prompt or copywriting a prompt. Are there any requirements that prompt specifically has to have?
So I heard about the requirement for prompts. What else was the question? I'm not sure. Bill, did you hear that?
Yeah, so I think she wanted to know what was the characteristic of a golden prompt. Is that correct?
Oh, it was just some language to say it's like a killer prompt. You could have a simple example of a prompt that I gave. It's just, I want a raise. Write an email to my boss, give me a raise, right? That's a simple one. And then the golden one is, it's like you go in great detail. This is what I've done, and this is what I want, and this is why I deserve it. And so that's what I mean by
a golden prompt is a more detailed, detailed and specific prompt that you've documented, put in date, time stamped, and kept it, and then that can be taken to litigation to help your case. Is that a good summary?
Yeah, I think so. Does that answer your question? Yes, great.
Hey, thank you for your time today, and this was helpful.
Great.
You mentioned documenting things along the way a few times, and I'll be very specific. Let's say AI did your performance calibration in a company. What exactly do you document, and is that practical in real world to document any of these, and even your interaction with AI, products, because you interact many number of times a day. So when you say document, can you double click on that?
It's the company documentation of an employee's performance. Is that what the question is?
That was a part of the question. The broader thing was, what do you document in many of these
Employee
possibilities? Yeah.
in the employee evaluations.
We can start. Yeah, we can look at that case.
Yeah. Okay. Well, so before AI, there were a number of things that a manager was required to document in their reviews of their reports. A lot of it is defined by the policies of the company. I used to work for Nokia, and we had a certain way of certain things we had to include in our approval. So whatever those criteria are, they need to be addressed in some written form. It had to be written writing, and it had to be articulated, and if there were issues, then you had to explain what the issues were. Typically, you had to give the employee an opportunity to or put them on probation, an opportunity to improve their work, to not be fired, things like that. That's kind of the documentation that a human would do. With AI, because it's a high-risk decision, basically the human needs to ensure that all that stuff is done. And that's where the human review comes in. On high-risk decisions, it must include the input of a human. Does that answer your question?
No, go ahead. Gotten up here, you got to ask the question. You're good. Okay. All right. I'm going to ask this. Is there anyone else? Okay, here we go.
Hi. I'm just interested in any case studies with respect to prompt ownership.
Yes.
Is wondering if there are any case law in terms of prompt ownership, what they were.
Of prompt ownership?
Yeah, so you create the prompt. How does it, is there case law around the prompts and the ownership of those and the use of those? That just go back to old patent law where you're documenting your work over time.
Yeah, sure. Well, typically the starting point would be the contracts, the employment contracts, the consulting contracts. If good work for hire agreement will have the prompts owned by the company. End of story. It's a contract that's enforceable by a court. If your question goes to implied, I think it depends on what the circumstance of the employment are. If an agreement is silent on that point, it would depend on the circumstances surrounding that employment. And there are factors used by courts to determine, even if the work for hire language is not used, whether indeed it's implied. And there are factors like, did the employee use the resources of the company? Was the work done on company time? Was it done is it a project that the employee was assigned to work on? Factors like that. Does that answer your question?
Okay. Am I audible?
Okay.
Yeah. So I'm just wondering, are there any employers that have already used like all the prompts that are used by the engineers, made a list out of it and then developed a model kind of stuff that could affect the engineers' workforce?
Bill, there's a little bit of reverberation there. Could you explain that one?
Because they already have the prompts.
So she was wondering, is there cases where the engineer employee created the prompts, once they had them, the employer didn't find any use to the employee and then fired them and continued to use their prompts. Is that correct?
So the employer fired the employee and continued to use the prompts?
Yeah.
So the answer is the employer owns the prompts, and firing is appropriate if the person fails to perform according to the requirements of the company.
Or if the company no longer needs it because they have the value of that property already. How do you perform an integrity check? Use other AIs to do it, or how?
It's a great question, and I think that's going to separate the winners in using AI from those that are going to fall behind. It's basically just your personal education, and you're developing as much experience as you can. I've given law, a partner would send me to the library for a week to do research, and that educated me and it gave the partner what he wanted. But today, a partner I mean, I do this myself. I don't need associates to do research for me. I'll have AI do the research. So suddenly associates don't get that learning curve. But I think the real challenge for people, the young innovators, technologists starting out is to learn that experience. Because that's what you need. You need knowledge and experience. I know, in most cases, I know what the answer is going to be. When a client has a problem, I know what the answer is going to be. The challenge is getting the case law support and then doing the analysis. That's, I think, what entrepreneurs and students just out of college and high school need to focus on is just learning that expertise to be able to sort of know what the answer should look like. And then the AI is going to do its due diligence and put out an output, and you can read it. In the case of that software example, you can read it, and I think the competent software programmer would immediately recognize the restricted code and pull it from the output. That engineer didn't recognize it because he or she didn't have the experience. So I hate to say it's a catch-22, but you sort of, it's kind of like when I start practicing law, you want to try a case, but nobody lets you try a case unless you have experience, right? So it's how do you get that experience? Well, you do enough depositions, and maybe you get a client that lets you try, it's stuff like that. But that's kind of what I think the young people starting out need to do, is they need to just look for ways to get experience, because that's what you need to validate the AI models. You need that. And that's what you also need to write and articulate good, meaningful questions and prompts, good prompts to get meaningful answers. So it's back to communication and developing expertise to validate your results.
Any other questions? I think this last point really points to the value of a college education, working in a research lab, which, as you know, I'm more of the going to the trades group, so I will stand corrected.
Great.
Thank you, Paul, for coming out here and giving us this education.
So a pleasure to be here. Thank you for having me.